she says none you need to be here for.
Oh, I'm sorry. Caldwell's the only one he's be here for.
And that's the one that's gonna take the longest, right?
Probably. I mean, that can be here for Todd. He's gonna hear it, but you're gonna pull it. So
Well, no, but we'll do call this first. You want you here for that, because you heard it, right? Came to your subcommittee. Okay. Is it good? Ready to go?
it's ready to go.
You sure?
It's gonna have opposition.
All right. Okay. How long you got before you gotta leave? 10 minutes, good.
Only get 5 minutes.
Oh, really? So ain't gonna be no, he ain't gonna be here for you.
You saw this list, right?
What list? Okay. This is the list of. Will you send me that list? Okay, welcome to the House Judiciary Committee. We apologize for the delay. Friday is not our normal meeting day, and several of us serve on two separate committees and both meeting at the same time, and we had to go deal with that other committee first because we thought it would be much shorter. But I appreciate you being here, and I appreciate your patience. Let's begin as we always do. If you would bow your heads with me, we'll start with a word of prayer. Lord, we pause now as always as this committee begins to ask you to be here with us. Give us the wisdom that we need to do what is best for the people of this great state. Lord, bless these committee members and help us as we move forward. Amen. Okay. All righty. Let's see. Why don't we, Miss Rich, start with your bill, House Bill 134. You're welcome to stay right where you are there and present to the committee your bill.
All right, thank you, Mr. Chairman. House Bill 134, we're working from LC 289084, amends the chapter of the code which provides for county law libraries, the funding of libraries and the management of them. It amends that to strike a provision that provides that counties with a population of 950,000 or more will no longer have the funds diverted to the county law library fund. Instead, they will be going straight to the county for disbursement and spending on courts in general, not necessarily law libraries. So this will affect 3 counties as of yet. That would be Gwinnett, my home county, Cobb, and Fulton. All 3 of those counties have law library boards that work very well, and they would like to continue operating and receiving the funding necessary to operate their own county law library. So this law will just provide for that to continue. And the ACCG and Gwinnett County, they are not in opposition to it, and I have not heard any opposition from Fulton or Cobb County either.
Okay. So, Representative, and of course, you may or may not have found the answer to this question during subcommittee or in the process of handling it. Does anybody remember why we did this to start with?
No, and I, since it's my first year, I was not here. I have asked that question multiple times. I know Representative Abstration said he thinks he knew at one point, but he doesn't remember now. Someone from ACCG said that it was because of Fulton County, but I really have no idea why that is
Would
there.
have been the first time we ever did anything down here specifically for Fulton County or because of them. I don't know why that could be it. Miss Silcox, do you have an answer for us? So you number 3 there?
The distinguished former chairman of the Judiciary Committee, Wendell Willard, contacted me on this bill, And apparently it was for the funding mechanism for the Fulton County Law Library. And he was very concerned that this would be changed. And I did check with Fulton County, and everything's fine.
So, but he didn't know why we did it to start with, to put in that 950 figure estimation. Mr. Chairman, do you know?
So I don't. The answer is no, and I never knew, but I've always had I felt an educated guess. And the thinking was that if there was a certain threshold, you didn't want an overly extravagant law library and excessive funds going to the law library, and there needed to be a threshold where that was drawn and that was set population-wise. That's always been my guess. It's my understanding that the history is that this has been increased in the past. The population has been raised, and the representative's bill, just to do away with it, would address that. And one of the reasons I'm a co-sponsor is, as I understand it, the filing fees collected once you've surpassed this threshold would otherwise go into the general fund. So there would be no required spending on the law library, which is the reason for the fee.
Okay. Wait. So we think we may know why we did it, but it doesn't seem to be a concern of anyone now. And any idea how much money is raised for the law library in any of these counties on an annual basis?
No, I don't have those exact, I don't have those figures at all. But the Law Library Board is governed by the Chief Superior Court Judge, the Chief State Court Judge, I think the District Attorney, and 2 attorneys in private practice who are appointed. So this is a very reputable, public service-oriented group of people who are managing these funds and doing what they think is best to provide a public county law library.
Okay.
Mr. Chairman, if I may, my recollection is in the last 5 years, we passed general law that requires an audit also of the budget. And so that safeguard has been put in place recently.
Okay, good. Anybody have any further questions regarding Representative Rich's bill? Is there anyone here signed up to testify or would like to testify regarding her bill? Okay. All right, well, we will deal with the bill as a committee at this point. Is the chair would accept a motion regarding House Bill 134? There's a motion. Is there a second? Any discussion? Hearing none, all those in favor say aye. Aye. Any opposed? Bill moves on to rules. Congratulations. Representative Rich, this would be your, what, how many bills have you passed out of committee now? Well, it doesn't. Should we reconsider the motion previously? Okay. Well, maybe she'll figure that out and fix it in rules. All right. I understand, buddy. Thank you. Okay, Judge Scoggins? You can stay right where you are if you'd like to. You want to come around? You got guests, okay? All right. We will.
Judge Betsy Kidwell,
Judge.
Magistrate Judge in Perry County.
And I'm gonna Judge Kidwell.
Yes.
In which county? Heard County.
She is the past president of the Council of Probate Judges. I'm not, excuse me, magistrate. I keep on saying probate judge.
It comes natural to him. He can't help it. Yeah. Speaking of judges, I should have done this to start, but we have a couple of judges with us today. Obviously, Judge Betsy Kidwell, Chief Magistrate in Heard County. Good.
Not chief.
Magistrate, okay, one of our magistrate judges in Heard County. But we also have one of our Fulton County Superior Court judges, Judge Sean LaGrua. Did I pronounce that right, Judge?
You did. Thank you, sir.
All right. Well, good to have you here today. We always appreciate our Superior Court judges and keeping tabs on us. I've told the committee before that it's good to have you here just in case we need to hold somebody in contempt. All right. Past judges have always had their pen ready for us if we needed it. So, all right. Judge, please, Scoggins, please proceed and tell us about House Bill 257.
Yes, sir. Thank you, Mr. Chair, committee members. I'm here today to talk to you about House Bill 257. This bill would make changes to Title 15, Chapter 10, relating to our friends in the probate, magistrate judges across the state. Looking at the bill, this bill gives the magistrate judges a little authority to set their own organization up, their own council of magistrate judges. It also removes some provisions that were done back in 1983 when the magistrate court was changed from the justice of the peace. It requires a new bond amount for each magistrate judge and some qualifications or the authority to sit as a magistrate judge. It changes some of those provisions. If you'll look, section 1, line 12, the council is authorized to organize itself and develop its own constitutional laws. Line 26 states that every county shall have a chief magistrate judge. Line 32, as far as the number of magistrates in each county, that is totally left up to the judges of Superior Court or is done by local law. Line 93 changes the bond amount for magistrate judges. It goes from $25,000 to $100,000. And section 3, 134, 135 changes the year of residence for anyone seeking to become a magistrate judge or a sitting magistrate judge. It goes from 1 year to 2 years. The bill also requires that you be 25 years of age, that you remain a resident of such county during the term of office, that you be a citizen of the United States, that you be a registered voter, and also that you have a high school diploma or a GED. And with that, I'm going to let Judge Kendall speak, please.
Yes, I want to thank the chairman and the committee for looking at our revision
Judge,
bill.
pull that mic around to you right there. Let's see.
I'd like to thank the chairman and the committee for their time and attention to our magistrate revision bill. Representative Scoggin stated, there's very few changes. It really just brings us in line with the state council and probate council on terms of 2 years of residency, being a citizen of the United States, and raising our bond to $100,000.
Okay. Judge, we appreciate you coming today. And my assumption is, and you may have said this, and forgive me, are you one of the officers of
I'm a past president.
Past president, that's right. Okay.
Yes.
Okay. And is there any, so it sounds like you said that you were mirroring what we did with the probate judge update
That is
bill
correct.
a little while earlier, is that right?
Correct.
Okay.
As 1510 states right now, a magistrate judge does not have to be a citizen of the United States. We would like to change that. And again, bringing our bond up to $100,000, and then allowing us to set our own council. Right now, the statute tells us exactly every officer we have to have in the council, and so that brings us right in alignment with probate.
Okay. All righty. Do we have any questions of committee members for either one of our judges up here? Is that you? Okay. Yes, sir, Ms. Holcomb.
Thank you. I'm not on the subcommittee that this came through, so forgive me for asking this now. I noticed that the educational requirements are very limited, high school diploma or GED. Can you explain why we're setting the bar there? And I know that it was in prior code, but just...
Yes, actually it is prior code, and we actually made a small change saying it had to be an accredited high school diploma. I believe the way that the statute runs now, it just says high school diploma or GED. So we just used the word accredited. There was a big discussion whether or not we should put more requirements into it, but again, we just decided we wanted to mirror probate.
Okay. So that once again is just what we did in the update of the probate code, right?
Correct.
Okay. All right. Did you influence him to do that, Judge?
I should have.
Okay. Any other questions from committee members of either one of our judges? Do we have anybody signed up to speak on the bill? Sign-up sheet over there. Is that, you pass that, Judge, if you'll slide that across the table, that'd be great for Jordan to get it. There you go. All right. Is there anyone else that hasn't signed up that has any desire to speak to House Bill 257? Okay. The bond from 25,000 to 100,000. That was also, I think I mentioned, similar to the probate judges.
That
right?
is correct.
Okay.
Mm-hmm.
And I guess Ms. Nesbitt, ACCG is fine with that because it's going to cost a little bit more money, right?
Yes, sir, it's not too much, and the clerks did it, the Superior Court clerks did that a couple of years ago, and the probate judges, and so, you know, it really is, they're really covered, if they're covered by ACCG insurance, they're covered. They
Okay.
really don't need the bond,
Right.
but it's not that expensive.
Okay. Good. Good. Okay. All righty. Any further questions from any committee members? Thank you all for being here, Judge. We appreciate
you.
it. We'll now bring the bill back to discussion amongst the members. Is there a motion regarding House Bill 257? There's a motion. Is there a second? There's a second. Any discussion amongst committee members? Hearing none, all those in favor of passage of House Bill 257, please indicate by saying aye. Any opposed? The bill moves on to rules, Judge. Good luck.
Thank you.
All right. Okay, next we have House Bill 177. Representative Caldwell, you want to come forward?
Yes, sir. Thank you very much, Mr. Chairman. This is deja vu all over again for you guys. So I bring to you guys today House Bill 177. Last year this was passed out of your committee as House Bill 704. I want to thank the subcommittee members for taking the time to work through this again this year. The challenge that we are attempting to remedy today is many of you may have, like I have, a sinkhole on your property, which
Representative,
is actually,
can you
yes,
hold
sir.
just 1 second?
course.
Excuse me. Do we have the appropriate, the copy of the bill that came out of subcommittee? Okay. Did he have a copy is what you wanted? Okay, I got you. All right, sorry about that.
No,
I
no
thought he was
problem.
asking if we had a copy.
Thank you.
He wanted to make sure you had one.
I appreciate that.
I
I have
apologize
mine
for
marked up
interrupting you,
last
but go ahead.
Perfect, thank you. So
Mhm.
just to be safe there, we're working off of LC 41-1853S, and this is the subcommittee substitute. The challenge we're trying to fix here is if you have a sinkhole that was a result of garbage being buried by the contractor who built your home, the reason for that is highly likely because it was common practice before the late 90s. And in 1997, the DNR came out with a rule and reg stating that statewide it would no longer be acceptable practice. The challenge we ran into is that on average it takes about 20 years for garbage buried to actually decompose enough to find, but you have an 8-year statute of repose on any and all contractor deficiencies associated with the home build. So there is one exception to that, which deals with exterior siding. And in that situation, the way that we have addressed it is by saying that you can hold the contractor accountable as soon as it's discovered or reasonably should have been discovered. We were trying to mirror that language here. So we're coming in and stating that as soon as you discover that sinkhole, you discover that garbage, then you have 2 years to bring action and actually hold that contractor accountable. What that does is it allows you the opportunity to actually hold them accountable, but also make sure that you don't sit on it for the next several decades waiting, right? So what we're doing is really simply giving Georgians the ability to hold bad actors accountable, which is something that should have been done a long time ago.
Okay. We, and this is not the same version we passed last year?
No, sir.
This
It's-
essentially is the same
yes.
version as the one we
It-
passed last year? Okay, all right. All right, questions from the committee members? All right, Representative Walensky?
Thank you, Chairman. How you doing, Representative Caldwell?
Outstanding. How are you, sir?
Good. Just for my understanding, would this allow to bring a claim from somebody who, this is going on in our neighborhood, so somebody who buried prior to 1997, would you be allowed to bring a claim if this passed once, no?
No, sir. So if it was done prior to 1997, it actually wasn't illegal activity. So my house was built in 1994, and this will in no way, shape, or form help me dig that garbage out of my backyard. But but for anyone who acted after the course of this becoming illegal, we want to make sure we have some form of accountability here.
Thank you.
Any questions from other committee members at this time? Representative Caldwell, we do have Representative Rich.
Yes, ma'am.
Is there a mechanism for someone who is considering purchasing a home to conduct or retain someone to conduct an investigation or,
It's a
like a
great-
home
That was
inspection?
my first question when this was brought to me 3 years ago, and there's no feasible way to genuinely find, unless you're going to run a metal rod every 6 inches down 20 feet into your yard, there's really no feasible way to find, because the problem is it's all different materials that could be buried. So there may or may not be metal included, it may be wood, it may be concrete. And that's part of why we're making sure we catch all of what that could be defined as, right? So it's that the capitalist in me says, well, do your due diligence before you enter into contract and buy a house. But the problem, you really can't expect a home inspection or any other feasible inspection that a homeowner might be conducting to let you know whether this was done, if it was done by a bad actor.
So how in the exercise of reasonable diligence will we determine when it should have been discovered?
Yeah, it's a great question. So that is in large part being left broad in order to make sure that when you go to dig a pool in the backyard and you discover a garbage pit that was waiting for you, like a constituent of mine did, that you have the opportunity to hold them accountable. Now, if you had dug a giant pit, found the garbage, and reburied it, and somehow that was able to be proven, then you have discovered that prior. You've exercised discovery, and you probably should have brought it before. So we're trying to make sure we catch all of those possibilities here. It's a strange one, but it's affecting thousands of Georgians. I can tell you, my neighborhood, I'm in a 12,000 home community, and every single house has one of these sitting. Yeah, neighborhood's not 12,000, but the association, all of Town Lake, it's your typical suburban cookie cutter late 90s build out, and every single house has one of these pits.
And I'm assuming that this is not something that's typically provided under homeowners coverage, or that there's an option to purchase
Correct.
coverage?
It actually can't be, because it's illegal activity. So it can't be insured for, it can't be, you've got to, the law was broken. Thank you for those.
Mr. Jordan? Reed?
The only thing I was going to add was what you had said to the committee was that you had a right not to have this buried, and all this is the remedy for that right that already existed, which is why this is not retroactive in any way. It's just giving you the remedy for the right that already existed.
Yes, sir.
Okay. Further questions from members of the committee? All right. Why don't you stay up there, Mr. Caldwell, because we do have, do you have a question? I'm sorry? Well, we have a witness. There's someone to testify on this one. So, if you'll just move aside right up there, and we'll have Austin. Austin, come on up. Please introduce yourself. I'm happy to hear from you today.
All right. Thank you, Mr. Chairman, members of the committee. My name is Austin Hackney, and I represent the Home Builders Association of Georgia here at the Capitol, and wanted to weigh in on this bill and thank Representative Caldwell for including us in discussion as we've tried to work through this issue. I think he addressed already, this is a practice that used to be perfectly acceptable and legal. The DNR came out with a regulation in '97 that changed that status. So, we don't want to advocate for people who are breaking the rules. We see a gap in the law that needs to be filled in, and we've been working with Representative Caldwell to make that happen in a fair way that doesn't expose our members as home builders to liability that has already expired, and that's something that we've worked through, I think. And so the bill, as he entered it, is we thought was a fair solution. What came out of the subcommittee was not that different. The subcommittee saw the wisdom to take out an evidentiary standard that that our group thought made sense, and I would just put it to this committee to say, that higher evidentiary standard that was in the original bill was a clear and convincing evidence. We thought that the complicated nature of a piece of property that might have been a family farm for 100 years before it was sold to a developer who sold it to another developer when he went out of business, who sold off individual lots to several builders who may have sold them again. That chain of ownership over the years and the different things that people were tasked to do when they owned that piece of property, whether it was burying their own garbage as a homeowner on a family farm, or whether it was a grader pushing, tree stumps in, or there was a builder burying construction waste. We wanted that higher evidentiary standard to be at the outset of the action, so that a judge could determine, that, well, this 2x4 that's got a receipt stapled to it, that's got a contractor's license number on it, I think that's pretty obvious who did that. But if it was just a couple of tree stumps, it's a little harder to determine, who that action should go towards. So I think that was the reason that we had talked about that evidentiary standard. And if it's, I would just kind of present to the committee that's where we were coming from on that point. And be here to answer any questions if anybody has any for me.
Any questions from members of the committee? Okay, we appreciate you being here today. Okay. Anyone else wish to testify on House Bill 177? All right, if not, we'll bring the bill back to the committee. And is there a motion regarding House Bill 177?
Pass.
There's a motion of do pass by substitute and a second. And discussion? Hearing none, all those in favor of do pass by substitute House Bill 177, please indicate by saying aye. Aye. Any opposed? You're off the rules.
Thank you, sir.
All right.
Thank you all very much.
Thank you.
Promise never to ask you about garbage burial again.
Don't speak too soon.
Yeah, I know.
All right. Okay. And I think that we're going to hold House Bill 181, or would you like to have it heard?
Yes, sir, I'd like to hold it.
You like to hold it, okay. So that completes our agenda today. We'll move House Bill 81 to our next agenda, and I appreciate you coming today. Committee members, thanks for being here.